Thank you for joining us once again for PM Express. My guest tonight is the Minister for Justice and Attorney General. He is Godfred Yeboah Dame. Thank you, Mr. Dame, for your time.
Thank you very much.
I want to start by talking about something that is trending now. It's the Achimota case against, the Rastafarian case. It's gone to court. The students won against Achimota. You represented I think the Education Ministry, correct?
Yes, the office represented the Ghana Education Service, and of course the office was also a defendant.
Okay. Let me ask you your initial reaction to the judgment that was delivered.
Well, I think first and foremost, it ought to be placed on record that it's a decision that has far-reaching implications, and there are many people who are also opposed to the ruling. Many concerned citizens, eminent citizens of the country and all. For me, I think that if a decision of that nature has to be applied, then clearly it must be subjected to the test of the courts in the higher echelons of the judiciary architecture. And I say so because the High Court constitutes the first step in the judicial architecture. Above the High Court are the Court of Appeal and in the Supreme Court. So I think that is not the end of the matter. It should be the soundness or otherwise a decision definitely has to be tested. We have to have a more definitive pronouncement on the merits of the matter by a higher court in the Superior Court of Judicial Architecture.
You talked about far-reaching implications. What's your reading into that? What are these possible far-reaching implications?
Right. So first and foremost, the long-standing rules and regulations recognized and enforced by schools in the country may have to be reformed. It may open the floodgates to the acceptance of various lifestyles by schools to the extent that the decision is hinged on human rights. It implies that adherence to a certain lifestyle or custom or culture of a certain person perhaps will have to prevail over the relevant rules and regulations applicable in schools throughout the country. That is why I'm saying it has a very far-reaching implication. And for such a decision, you do not just leave it at the High Court. After all, this decision is not binding on the High Court itself. It's not binding on a High Court differently constituted. So you can have another High Court constituted by a different justice taking a different view of the matter. And you already know which way to go. So it can lead to uncertainty, and I think that there's a need clearly to have a clear, definitive pronouncement on the matter, the extent to which certain practices claim to be religious or claim to be even cultural or to be recognized and accepted in schools. So it is not just a matter of Rastafarians being permitted to wear locks or not. What about a traditionalist who would also want to insist that his culture enjoins him to walk barefooted? What about a traditionalist who also insists that, in accord with the tenets of his custom, is supposed to just wrap a cloth around his waist, even if the person is male? And for that matter, the school cannot restrict the manner in which it dresses. It could even have implications for whether school uniforms ought to be enforced. Because if I also insist that, well, I do not have to wear school uniforms on account of a certain factor here, or are you saying that ought not to be permitted? That definitely will be discriminatory. So we ought to really see the soundness of it. I was not in court, so I've not seen the ruling, and therefore I've advised that I obtain a copy of the ruling before I examine the soundness or otherwise. Either way, it's not changing the situation. I think that the merits of it will have to be tested.
So I've heard somebody introduce this thing called the floodgates theory, which means that this could open the floodgates for everybody else to sort of come and make these claims. And I've heard those on the other side of this theory suggest that this case was purely a religious, an attempt to enjoy religious rights. And if you come to the school and you say, well, I just want to put the towel around my waist because it's my tradition, it may not necessarily be a reflection of the outcome of this case, because they went to demonstrate that Rastafarianism is a religion and it's a constitutional right then to enjoy the fruits of that religious rights. Did you see the distinction there?
No, I do not see the distinction at all, because it's not only religious rights that ought to be respected or acknowledged in schools. There is also the right to exercise a person's culture. You cannot take away from the person the right to live his life in the manner in which he desires. That is why most of the time the yardstick is whether a person has attained adulthood or not. Indeed, the Constitution itself, Article 14, Clause 1, Paragraph E, says that the restriction of a person's personal liberties is allowed if the person is under 18 years, and that restriction is for the purpose of education or welfare. So really, inherent in Article 14, Clause 1, Paragraph E, is a recognition that a person's personal liberties can be curtailed if under 18 and it's for the education and welfare of that person. So that is why they can insist on a boarding student not leaving the premises of the school, the confines of the school, except with the proper permission given by school. Well, otherwise, you would say that you have the right to freedom of movement.
Mm-hmm.
So freedom of movement. Nobody can curtail Evans's freedom of movement. Nobody can say that Evans should be housed in a certain hostel or accommodation from, say, 14 January up to, say, 13th
eat
of
at
May.
A certain time,
Yes, eat at a certain time, wake at a certain time. Yes,
time.
yes. So the permission to regulate the lifestyle of a person under the age of 18 for his education or welfare is granted by the Constitution and is accepted. Mm. Now, the extent to which that restriction can be enforced when it comes to religion, culture, even health, and what have you, are things that I think that will always become a silent matter of disputation and contention in court. And I'm saying that it is very necessary that even say Court of Appeal, constituted by 3 judges of the court, who clearly will be senior to the judge of the High Court, or the Supreme Court, constituted by 5 justices of the Supreme Court, very eminent and the highest court in the land, no doubt takes a view or a position on the matter. It cannot just be left to the High Court. Determination of a justice of the High Court whose ruling is not binding on another justice of the High Court.
Yeah. I mean, immediately though, the 2 students, can they show up at Achimota and see to enjoy this, right? Sure.
So that's the result of engagement that I've had today. Today, the Minister for Education gave me a call in the morning. I expressed my view that I think that, yes, an appeal will be proper, since it will only lead to either a refinement of this ruling or perhaps a statement of its unsoundness, with all respect, by the Superior Court. So that ought to be done. Secondly, I think that even when the soundness or correctness of the decision is being tested on appeal, there is no justification for a stay of execution to be filed. So it had come to my knowledge that Achimota School had filed a stay of execution. So
they have filed? They said they will file, so they have to done it?
Yes. Okay. That is a matter of record. So I told the Minister for Education that my view is that the stay of execution should be withdrawn. I had other engagements with the Council for Achimota, as well as the Chairman of the Board of Governors of Achimota, Professor Aite, and my position to them was that, yes, they may pursue their appeal, but I advise that the stay of execution be withdrawn. And they will adhere to that advice or directive. So the stay of execution will be withdrawn. And it will be withdrawn for 2 simple reasons. I think first and foremost, if there ought not to be any act which will impede or hinder the education of the students in question. The government's policy, the president's main concern is to ensure that all persons who are worthy of secondary education attain same. So the president will be concerned about any action which will prevent a person from going to school. So the students ought to go to school, the school ought to open its doors to them. Secondly, an appeal can be contested without a stay of execution. An appeal can be pursued without the grant of a stay of execution order. Unless it can be shown that the grant of the stay of execution order is so imperative or compelling, and that its denial will lead to some injustice and all. In the meantime, any injustice perhaps will just be interim. So I think that the stay of execution be not pursued, that the school can pursue its appeal the government may even consider, after studying the ruling, whether it will also associate, file an appeal, and will not, in that circumstance, ask for a civil execution. So the children ought to go to school.
Okay.
The consequence of it is that if we succeed on our appeal, there will only be a reversion to a state school ante. There will only be a reversion to a situation prevailing before.
So the students will have to give up, to withdraw from the school?
Nope, not withdraw from the school.
Okay.
I think it's very important to place on record that the school did not withdraw them, or the school did not say that they had been expelled. The school only insisted on enforcement of its rule and regulation, which required keeping of the hairstyle in a certain manner, or cutting the hair low. I think that's the exact rule, cutting the hair, keeping the hair low. So that is not a denial of admission or education to the students. But because the students found it incompatible with what they perceived to be their religious expression, and found it incongruous for them to attend the school when their hair was low, they found it inappropriate, they decided to stay away, as far as I know. I do not, the school insisted that yes, the admission is given to you, you could attend the school, but in accordance or in conformity with our rule or regulation, which requires your hair to be kept low. So that's it.
But the effect of that is that they could not enroll, although they've been admitted, they could not enroll in the school.
I think it's just akin to saying you cannot enroll unless you wear a uniform.
True.
Yes, or you cannot enroll unless you bind yourself to wake up at a certain time. It's not correct if you're a boarding student.
Yep.
You cannot be a boarding student unless you stick to regular times at which you either wake up, go to school, dine in, you attend classes and all. You cannot say that, well, even though I'm a boarding student, the practices that were prevailing in my home, whereby my dad would come and wake me at 7:30, will prevail. You may have to wake up at 4:30 in my former school, and then all that. So that is how it is.
Okay, so what, as it is now, for clarity and for the parents who will be listening to you tonight, tomorrow they can take the 2 children to school.
That's my advice. That is my advice. My advice to the school, my advice to the lawyers at Achimota, my advice to the Minister for Education is that the school should open the doors to the students. And the Chairman of the Board of Governors expressed willingness 100% to comply. I mean, with all respect, I'm the principal legal advisor to the government, and that is my position. It's a public school, and that is my advice to them, and that will be complied with.
So they will go to school still with their dreadlocks on?
In the meantime.
Okay.
And I think that not so much harm will be caused if, say, within 6 months, 9 months, or a year, the Court of Appeal or even the Supreme Court gives a determination, makes a determination in the favor of Achimota School and requiring them to keep their hair low. Nothing will be lost. Then the hair will have to be kept low.
Or they can.
Otherwise, they can be suspended. Yes, they can face the necessary punishment set out the school rules and regulations. If your headmaster says you should do this and you don't do it, what's the consequence? You can be expelled or you can be suspended.
According to the school's rules?
According to the school rules,
which you sign on to when you're
regularly, yes.
I mean, so just for clarity, tomorrow, yes, if you're a parent and your student go to school,
yes,
this case will travel its course possibly all the way to the Supreme Court.
Perhaps. Yes.
If you still win, you continue. If you lose, you will either have to remove the dreads or you take the school's punishment. If it's that you can't continue to come there, you face that consequence.
And I expect them to then comply, because to do so means that they are defying the orders of either the Court of Appeal or the Supreme Court. Will it not? It will also imply that they're not law-abiding, and I think that if they are law-abiding, as we all required to do, you ought to respect the decisions emanating from our Superior Court, which are also part of the laws of Ghana.
There's somewhat held a view that the school's board, it's an independent entity and they can sue and can be sued. And so, regardless of your advice, they can still go ahead and do what they wish to do legally.
Nope, they cannot, because within the full gamut of law affecting the school is the Pre-Tertiary Education Act. The Pre-Tertiary Education Act constitutes JNES as a body with powers to supervise all public schools. JNES, the Ghana Education Service, is under the Ministry of Education, is subject to the advice of the Attorney General. All the time we give them advice on various issues. We represent them in court and all. So JNES cannot, it will be incongruous for JNES to be vested with powers of managing or administering your school, and the principal legal advisor to the government to give advice to the government that and ministry as well as the school that do this, and you will not do it. I think that we perhaps overstretching our imaginations. I think that they will comply.
Explain to the layman who will look at the case itself in court and said, but the school had their own lawyer and you were also represented, and so doesn't that explain the distinction between yourselves and them?
No, because in the scheme of the Pre-Tertiary Education Act, the Board of Governors of every school, high school, has been vested with the duty and function to administer schools in accordance with rules and regulations made by the Ghana Education Service. So there are specific functions given by the Act, and they can be sued, and indeed they were sued. And having been sued, they have the right to represent themselves. They represented themselves, and there's nothing incongruous about that. The Attorney General also cited as a defendant, and the Attorney General was represented. So,
your initial fear was the far-reaching consequences, but based on your advice, can anybody else in any school across the country right now say, well, in the interim, they can go with their dreads? If I also want to go right now, I mean, until the appeal is heard, I can also do so. But currently, there's a pending case of Wesley Girls, where the school says you can't fast.
I think that's a different matter.
That's okay, great. but as your fear was that this can open the floodgates. In the interim, you say you can go with your dreads. Can also others who may find themselves in a similar situation, cultural expression, etc., also say, well, in the interim, whilst we wait for the Supreme Court to eventually can also exercise and enjoy that right?
Well, so the point is that a school properly taking a legal view of the decision of the High Court can say that this is a decision of the High Court. It's not binding on another High Court. Neither is it binding on any of the courts in the the higher echelons of the judicial architecture of state. And for that matter, they are also enforcing their rules and regulations in a certain manner. What will happen is another parent can take the action complainer off to the High Court, can challenge the validity of the action complained of at the High Court. And you'll be surprised that another justice of the High Court, or the High Court differently constituted, as the lawyers would say, can give a decision to the contrary. You know of this situation where one justice of the High Court gave a ruling to the effect that demonstrations, I mean, if they have to be curtailed by the police, the police can only do so pursuant to an application on notice and never ex parte. That decision has been departed from by many judges of the High Court in different matters. And there has not been anything wrong, because indeed the High Court decision was not binding on another High Court differently constituted. You know about the Face the Country demonstration where an application ex parte was granted by a justice of the High Court and was valid.
In the absence of the court intervention, though, can anybody else try to exercise this right now, getting a judgment and going to a school and say, oh, listen, I also want to enjoy this right?
Well, I think that even when they had no High Court judgment, other schools permitted the
in fact, this same child
was admitted.
They have
under school.
There's a triplet. Their two sisters are in another senior high school with dreads, and they've been allowed to go. So
really, it becomes a matter of enforcement of the rules and regulations. There are schools which entertain burden of mosque on their campuses. There are schools which do not.
Like my school, very progressive one, St. Thomas Aquinas. I don't know which one you went. Well,
mine is more progressive than you, and perhaps yet we do not have a mosque there, and it's proper. It's lawful.
Then you can't claim that you are more progressive than us.
I think that we have to have a proper, and that's actually one issue that I have with those who support gay rights. They think that it's not progressive for you to advocate against gay rights. I do not understand. I can't come to terms with that. The fact that you find it appropriate to advocate for the rights of gays and lesbians, that's not mean that I should also not have the right to advocate against that practice. And indeed, one of my earlier engagements with some high commissioners here, I made a point to them, high commissioner ambassadors, that, well, I should feel free to, our nation should also feel free to advocate against the practice of lesbians and gays. So the fact that your school perhaps not so recognized, entertains a mosque there, does not mean that I decided, which of course is more prominent than yours, is not acting appropriately by not having a mosque there.
Well, okay. I mean, this is a debate we'll have after here. You could be the judge for that later.
Right.
But at least you've settled this matter
yes.
for the parents
who
were torn on the back of Achimota decision.
And for me, it's a very fair compromise, very fair situation. That yes, you can challenge the correctness or decision of the High Court because you're a party to the matter and your right to appeal cannot be taken away from you. But in the meantime, let the president's policy to ensure access to education be granted to all. And even indeed the Court for Appeal or High Court, Supreme Court rules in your favor, the effect will still not be a deprivation of the president's policy of free of education, grant of access to education for students of secondary school age. It only means that they have to comply with the school rule by cutting their hair low. Simple as that. So
fundamentally, I mean, just for those who listen to your argument, you want at least a pretty far-reaching pronouncement, possibly at the Supreme Court, that will not just look at this case as in a specific case of either you can go with Arasta or not, but have a more far-reaching decision,
precisely.
Well-reasoned, that can guide education going forward, because this will be landmark if indeed it gets there.
Yeah, it will be. And I must also place on record that the Ghana Education Service is actually in the process of enacting rules and regulations as required by the Pre-Tertiary Education Act. So they need such a decision. They need such a definite pronouncement. Yes, pronouncement on the issue to guide them. And it will also be helpful to our office when we are reviewing the rules and regulations for them to see what may be permissible, so that we may not even have a litany of suits in future based on certain specific issues.
So that is Godfred Yeboah Dame there. I want to take a quick break. Thank you for staying with us here on PM Express. My guest is the Attorney General, Godfred Yeboah Dame. Mr. Dame, so the fight against illegal mining, there are two controversial issues currently, which is pretty controversial for a lot of people. One is the banning of excavators. The critics, including Occupy Ghana, a lot of senior lawyers join members of Occupy Ghana, they argue that the law doesn't empower the state to do what it's doing, and that it's actually downright illegal to ban excavators. The president had been clear that he believes he's in the right side of the law and challenge people to go to court. Do you agree that this is illegal?
Definitely not. I mean, because I think that it must be placed on record that the Minerals Mining Amendment Act sets out the procedure for prosecution of a person who is caught in illegal mining or a person who is trading in gold or other minerals without a license. And then the law also sets out procedure for confiscation of, if I may say, forfeiture of the equipment used in such an act to the state. And the procedure is quite there. But it does not divest the state of any other option at all. And I say so because I personally prosecuted a matter involving the state, Estin Kubik and Attorney General in 2018. Now the plaintiff in that case had sued the state for unlawful detention of its equipment at the police station in Kumasi, Ashanti region. So our contention was that to the extent that the equipment were being used for unlawful purpose, in the sense that Estin Kubik did not have the license to mine and they had been on the land to mine, no damages whatsoever could be asserted on the basis of an unlawful activity. The High Court, going through the motions and all, came out with a judgment, a 69-page judgment, in which it definitively held that no right whatsoever can accrue from an illegal act. No right whatsoever can arise or result from an activity which clearly has been prohibited by law. And so the position that was expressed by the president in his address at the sword cutting ceremony of the new law school premises was actually one that was anchored or hinged on a decision of the High Court in Kumasi. And how the decision here, just for the benefit of our readers, viewers, so see, Estin Kubik versus the Attorney General, the Regional Minister, the District Chief Executive, and Chuma Punua District Assembly. A decision rendered on 14 June 2018. And if I may quote from pages 62 onwards, it says, in his book, Essentials of the Ghana Law of Evidence, the learned author, S.A. Brobe, that's with the Supreme Court, as it then was, stated as follows with regards to public policy and illegality. No individual is permitted to use the law to perpetrate the commission of a crime. In civil cases, the rule is that a person cannot found an action by an illegal act, commission, or conduct. And this is encapsulated in the Latin maxim, est tepi causa non oritur actio, or ex dolo non oritur actio. End of quote. That goes ahead to also quote at page 66. In the instant case, the reported leases based upon which the applicant was sending the equipment were all null and void and conferred no rights on the applicant. Therefore, the activity which the equipment were being carried out and performed was nothing but an illegal activity. It therefore stands to reason that if the equipment were found in the Ekrima Ponua District Assembly illegally and were going to be used for illegal mining, then the respondent, by seizing and detaining them, breached no rights of the applicant, which required the court to grant him any remedy. The conclusion is quite instructive. The conclusion is from pages 68 to 69. It says, from the foregoing discussions of the law and the facts of the case vis-a-vis the various legal submissions, the court is of the opinion that the acquisition of the mining leases by the applicant breached statutory or constitutional infractions, which made the purported execution of the mining lease or a nullity. Hence, the applicant had no mineral rights as expected by Section 9 of Act 703. So it is safe to say that the equipment were going to be used for an illegal mining, known in our local parlance as galamsey. As such, the seizure and detention of the trucks and the equipment were justified. This is a decision of the High Court, Kumasi. And this decision was actually tested in the Supreme Court. The lawyers in that case were Osafo Babin and Ejuji Tamaklo. They lost. I was the counsel for the state in that matter. And so even at the Supreme Court, the application for certiorari was also dismissed. So as far as I'm concerned, this decision of the High Court, Kumasi, has not been challenged. The same was appealed by the Supreme Court after an application for certiorari had been dismissed. So what is the illegality about the exercise?
But this is a court of
and I'm yet to know of any decision to the contrary by another High Court or any court at all in the country on the same matter as Galamsey.
Yeah, but a court of competent jurisdiction has held, as you rightly say, that no rights can accrue out of an illegality.
Yes.
In this case, say, military officers are on the ground making unilateral decisions as to this mining equipment has been used for an illegality and therefore banning it. That isn't what the court has done here.
So the same case, the facts leading to...
had been seized before you went to court.
Precisely. The equipment had been seized for over 1 year at the police station in Kumasi. The plaintiff in this matter contended that the seizure was unlawful since it amounted to determination, as you said, by this assembly unilaterally. In fact, by the regional minister unilaterally. And that it also amounted to a violation of their right of a hearing and that kind of thing. So those contentions were made, and this was the ruling. The ruling was to declare that no illegality can give rise to any right.
But that's not the distinction between seizure and distraction.
Oh, so you're now thinking about the severity of the action. Yeah. So the point is that either way, it is punitive. Punitive in the sense that your equipment had been seized and detained for God knows how long. You have been deprived of the use of it. They were claiming as much as about 12 million, total of 12 million Ghana cedis, and that claim was dismissed. That is so different from the banning of the equipment. It's a principle that ought to be underscored. The principle that no right whatsoever can be conferred on a person who is engaged in illegal or criminal activity. And that, for me, is the most significant point. I think that, yes, I recognize that it may seem harsh to you, and that's why people are complaining, but it may seem harsh to you. What about the far-reaching, devastating effect on the nation? There's an activity that has resulted in pollution of our water bodies, massive destruction of various towns and all. It has actually been weakening the foundations of certain towns. And these are acts that have generational effect. So it has effects even beyond our generation. I think that the monumental damage that is being caused ought not to be, or side ought not to be loss of that. And that is, for me, that is what is most important. And I find it, with all respect, a little bit reprehensible when people, instead of rather ensuring that the government leaves no stone unturned in its efforts to bring to a halt this menace, rather advocating for recognition of some non-existent rights of persons engaged in the
But
act.
if you ban the excavators, in the Eston Kibu case, you seize, and so the evidence was still there. If you ban it, what's the evidence to prosecute?
The evidence is there because we first and foremost visits to the scene were conducted, pictures were taken, pieces of the equipment were also taken, even the fact that the equipment were in water bodies. All there, the evidence was there. So there clearly has not been an undermining of our effort to prosecute the case effectively. And that leads me on to the issue that you said that, yes, people
the prosecution.
Yes,
I'll come to the prosecution, but there's a quick one that just occurred to me. The law that the opponents to this banning had cited is that the process is you seize, give the police custody, eventually the minister can repurpose. In the Eston Kibu case, you appear to have complied because you seized.
No, we just seized the equipment.
Yeah, but that's what the law says you should do.
Yeah, but
in this case, the law, you've actually bent the equipment, which is contrary to what the law says.
No, what we have done is to decommission the equipment, decommission them in a
set
way.
in fire to it.
Yes, but I'm saying that, yes, so it still does not divest us of the decision to deal in a manner as
but
appropriate.
But that's not what the letter of the law prescribes.
No, but I'm saying, no, that letter of the law is for prosecution. The provisions are for prosecution and what ought to be done consequent upon prosecution. So if you want to prosecute the matter, we cannot prosecute in any other manner at all. But I'm saying that let any person also refer us to no authority which contradicts decision in Eston Kibu, where it is the principle is stated that no illegality can confer on any person any right whatsoever in the country, and that's it.
You have the power to amend this law, though. Why don't you simply do that?
To amend it to do what?
The law that prescribes the procedure for dealing with mining equipment used for illegal purposes.
Right. So that amendment, if pursued, will only have the effect of
regularizing.
No, not regularizing. Not regular. I think the way it's not regularizing. It will have the effect of casting in law, in more definitive terms, such an action that ought to be done. Simple as that. It does not mean that it's illegal. It's not every conduct of yourself which is prescribed for by law, in hard law. It does not mean that such conduct, if not prescribed for by hard law, is illegal.
At least, some say, at least amend the law?
I think that is what the president is saying, that if they think that is illegal, then perhaps we have to test it in a court of law. And that's what people also think that perhaps is a little harsh. He's only saying that the laws of Ghana recognize a certain institution for the determination of illegality or otherwise. And therefore, if you are contending that his action is, or an action by an authority of state is illegal, have recourse to court.
Why is there what people see as a fixation on banning of the excavators and not prosecuting the people behind the excavators?
But who chose the so I think that it's also one erroneous impression that has been created. There's a lot of prosecution going on. On Saturday, I had occasion to speak on your radio, the network, Joy FM, and I alluded to as many as about 46 persons who have been prosecuted, 45.
Prosecuted or being prosecuted?
Being prosecuted since May, since 12th of May.
2021?
Yes, people were arrested on 12th May, 14th May, I think 17th May, and even just last week, even just yesterday, people were arrested. So as of the time I was speaking to you on Joy FM, as far as I was concerned, there were as many as about 45 or 46 persons who were being prosecuted in 5 different cases. And it's very important to note that that prosecution involved as many as 10 Chinese nationals. So I think that the memory of all of this Aisha Wan has been banished forever. The memory of Aisha Wan should be banished.
Do these include foreigners?
Chinese nationals, foreigners, clearly they are foreigners. So you have various cases that I can cite, Republic vs. Wei, Ganyan, very young, Moiji, and others. They're all Chinese nationals. And there are 10 Chinese nationals. And even yesterday, some were also picked up further. So there's a lot of prosecution going on. Arrests have been made every day. And when they are arrested, they are gone, they are processed before court and all for various offenses. I think even yesterday you heard about this a matter involving some Chinese nationals who were operating a casino in one village. So
Let me throw in a concept of the beneficial owners. Are these beneficial owners, or these are people you arrested on site?
These are people who engage in acts prohibited by law. They are engaged in acts that have been prescribed and which clearly are illegal, criminal, and they are being put before court.
Is there illegal a desire to pursue beneficial owners who may not necessarily be on the site to arrest physically? Even
one of the probably was a young Morjin. Interrogations revealed that the persons who were behind are both Chinese and Ghanaian. So both persons, even though they are on the run, are being pursued. So ultimately, we'll bring all them.
The monster of illegal mining has.
The thing that most important thing is to set an example clearly to Ghanaians and to the whole world that you cannot engage in the destruction of our environment and go scot-free. And whether you are a Ghanaian national, whatever nationality you belong to, you'll be prosecuted. And when you are prosecuted, the new amendment, which was effected pursuant to the efforts of our government, is that you serve your sentence in Ghana. The amendment to the law, which was effected in 2019, which prescribes a penalty of at least 15 years, a maximum 25
Even when
years.
You have an extradition
for
treaty
a Ghanaian. Hold on, that's for if you're a Ghanaian. If you're a foreigner, it's minimum of 20 years and maximum 25 years. That amendment was effected pursuant to efforts by our government in 2019. And it also further prescribes that if you're a foreigner, upon conviction, you serve your sentence fully in Ghana without the option of...
Regardless of extradition treaties you may have with the counterpart.
That's what the law says, that no extradition will be effected. You serve your sentence in Ghana.
I was making a point
about... I'm saying, so for now, the media should stop talking about Aisha Juan, but the memory has been banished forever.
The monster of illegal mining has rested on the fear or the perception or the reality, I mean, choose which of the descriptions, about political powers who may be involved, and they are more difficult to rein in. Is there desire to look there too? Is this something that have you ever averted your mind to?
100%. There will be an application of the law regardless of political, religious, ethnic, or national
Even if they are MPP members?
100%. I think recently reports came out about the destruction of an equipment alleged to belong to the National Women's Organizer of the ruling party. And that, for me, is a classic example of an even, non-discriminatory, and fair application of the law. That regardless of who you are, your equipment will be bent, and that's what we are doing. And you will be prosecuted if evidence is found that you engage in it.
Yeah, but so why is she not being prosecuted then?
So investigations are underway in respect of that matter, and if indeed we find her to be personally involved, she will be prosecuted.
I want to take another very quick break. When we return, there is a case that just been decided on by the courts. This saves the country more than 1 billion cedis. This is the NDK finance case. You may have forgotten, but the case was just decided. I'm going to be talking to the Attorney General about it. Stay with me. Thank you for staying with us. My guest is still the Attorney General. He is Godfred Yeboah-Dame. I mean, Mr. Dame, so we heard today that you've just won a case that may possibly save the country in excess of 1 billion cedis. This is the NDK finance matter.
Yes, it is.
How did that come about?
Well, I think it's actually true. The state was saved 1.27 billion Ghana cedis. It is as a result of an agreement that had been entered into between the state and an entity in 2007. The agreement was for the state to guarantee a debt that had been applied for, a loan that had been applied for from NDK Financial Services, because that entity was discharging services for the benefit of the government of Ghana. And an amount of 268,000 Ghana cedis had been guaranteed by the state. So NDK decided to pursue the state for it, started all the way, I think, 2010 or so. Judgment was given against the state, and there was application of compound interest. You know how these financial institutions are. The compound interest computation of it can have such devastating effect on you if you are at the receiving end. So when we came to office, we decided to settle it that, well, we're going to end, we'll pay maximum 79 million Ghana cedis. That was paid. in 2018 or so. NDK Financial Services continued to pursue. They decided not to honor the understanding that we had and decided to say, contend in the Supreme Court that they were entitled to over 1.297 billion Ghana cedis. We found that very offensive, that it definitely be an unjustified drain on the public purse. So I filed a process challenging it. That was about 2019 or so. It's been pending for quite some time. For the state, for the Supreme Court to hold that the amount of 79 million Ghana cedis paid was in full and final satisfaction of any obligation to NDK, regardless of whether there was a settlement or not. I mean, we were of the view that state had finished paying, that it would be inequitable and unconscionable for NDK to be exacting 1.29 billion cedis against the government of Ghana. And today the court came up with a judgment, and the judgment essentially upheld our contention, and the Supreme Court held that we owed only 14,000 Ghana cedis, and that interest should be applied on it. That's in accordance with normal commercial bank rules, commercial bank rate from 2014. And the computation of that would lead us to pay not more than even 1 million Ghana cedis. So we've been able to save about 1.29, in excess of 1.29 billion Ghana cedis. And
will they seek review? Will they seek a review?
No, I doubt, because really, even that was a special application that I made, an application that ordinarily would not even be countenanced by the rules of court, because the matter had already been dealt with by the Supreme Court to conclusion. There had been a review judgment given, which affirmed the earlier order for us to pay at compound interest. So I wonder how within the scheme of the rules of court they can even apply for a review of this. But even if the review is sought, was a unanimous decision of the Supreme Court. I do not expect it to be varied or set aside, and so that is it. It's part of the duties of regular duties of the Attorney General. We save the state money all the time, but people do not seem to know.
NDK, are they still an existing entity? I thought they were part of those financial institutions that may have been affected in the cleanup. Oh
no, it's a going concern. It's not being wound up. It's existing and operating. Yes, I don't think.
I mean, so clearly, you have to make this payment to them, and you've saved the Finance Ministry of Government a lot of money. The Finance Minister should call you.
Well, I think I'll just get a handshake or an elbow bump, as it is.
I mean, this liability, was it your government that incurred it, or it's
no, it was incurred.
You inherited.
You inherited way back. Transaction that started from about 2008 onwards. Continued then. The actual case was filed in 2010 or so, and all that. So
there's a bigger problem though of how the state sometimes handle these matters that seem to just drag. If you don't have a diligent Attorney General's department, it falls through the cracks. One time we had the whole sole commissioner to look into the matter. It doesn't seem to have dealt with this at various levels of government.
Yes, I think that there's a clear and urgent need for state officials to act with diligence, as you indicated, and in my earlier interactions with the head of civil service when I assumed office, I sent a notice to him that any public official whose act either deliberately or negligently results in loss to the state will have to be sued. And I will sue. I'm the Attorney General. I'm supposed to commence legal action against such public officers and all. So we'll do that, and I'm sure such process will lead to perhaps a reduction in such tendencies, if not an abatement at all. And yes, I agree that it is very worrying for the state, and it leads to a state bleeding, and it's public purse and must be protected jealously.
I mean, just before
but since we came, yes, there have been many instances of us saving the state similar amounts. This is a African automobile judgment debt, which we saved also billions of cedis and all. So we are on the way to getting there.
Just before we wrap up, I mean, you've been in this office, what, 3 months?
I think so. I think my 100 days will be next week or so.
So we are about to achieve a milestone.
It's even on my birthday, June, I'm sure.
Oh, interesting. Because I'm curious.
Just about the following week.
Just about. Yes, how has it been the last 100 days?
Finding my feet, very difficult, no doubt, because you combine all the various schedules, criminal, legislative drafting, civil, and all. But because I was Deputy Attorney General to Madame Gloria Kufu, who of course left a good legacy, I think that the transition has been quite smooth, and so I'm not entirely new. Of course, I handled the civil schedule, but I'm also certainly involved with the criminal division as well as the director of the legislative drafting division as well. Yeah. So it's good. And I think that it also comes with having a proper understanding of the role of the Attorney General. Attorney General to be the vanguard of the rule of law. Apart from that, too, you also have to be a sound advisor of government and ensure proper compliance with the law. And these were things that I was always cautious and mindful of and all. So and I can only look up to God to guide me and count on your goodwill as well.
Yeah, I'm sure you can't wait.
I hope the harassment in media will see.
I mean, Attorney General's office is a place you last harass because you rarely get Attorney General to harass. Yeah, I guess you can't wait for your deputy to come through now.
Yes,
to give you some some relief.
Yes, and they are very competent people. I've known them personally. They are persons that I had absolute confidence in and all, and I'm sure they will justify their nomination and appointment. And I'm sure they will see it through the vetting. Yeah. They do not have any cobwebs. I mean,
hopefully, because you don't know until it's done.
But they're fine people, I think.
But the rumor was that you are the only minister the president said, choose your 2 deputies. Is that true? I've heard that. I said that you're the only person the president said, Godfred, choose anybody you want to work with, and I'll say yes to it.
I would say that Article 79 one was complied with. I was consulted. so yeah, but I think I'm very grateful.
As the president has a lot of faith in you, that definitely shows that.
I think that I'm very grateful to the president for giving me the opportunity to fully express my views on who the deputy would be, the kind of persons I wanted and all. And ultimately, I think it applied across board to all the ministers. They were properly consulted and they made their views known and all.
That is the Attorney General. He is celebrating 100 days, possibly on his birthday. We wish him all the best. He has a long time.
My mathematics is not correct, so I'm not too sure whether it's exactly my birthday, but it's thereabouts.
Possibly, so yeah, thereabouts.
The lawyers should say thereabouts.
Thereabouts, okay. so we wish him well on this journey. 4 years. Some say he's possibly the youngest Attorney General. He says he's not. You say you're not, right?
So there was a gentleman that was older than me by 2 months.
Okay.
So I'm younger than him by 2 months.
That's an evidence of his diligence. He even checks tiny details as two months difference in terms of. But Godfrey, thank you very much.
Yeah, sure.
Enjoy the rest of the day.
Thank you.